This is Docket 27 from the Harco versus Wayfarer Studios. Letter motion to allow and incorporated SIR reply in opposition to defendant's motion to dismiss or stay. Dear Judge Lyman, Plaintiff Harco National Insurance Company respectfully submits this letter motion pursuant to Rule 1C of Your Honor's Individual Practices in Civil Cases in support of Harco's motion for leave to file a SIR reply in further response of the defendant's motion to dismiss or stay this action. As discussed below, this SIR reply is appropriate and should be granted to allow Harco to address the multiple new cases cited by defendants for the first time in their reply memorandum of law. Before filing this letter motion, the undersigned attempted to confer in good faith with defendants' counsel by telephone on December 22, 2025 to obtain their consent. Defendant's reply cites 11 new cases addressing abstention as further support for its motion to dismiss or stay. Each of these cases are readily distinguishable from the circumstances of this case or support Harco's position that this court should not grant defendant's motion for abstention. Had they been cited in the opening brief, Harco's opposition would have made these points in its opposition. First, 7 of the newly cited cases do not support the argument that the state court action need not involve the exact same parties and issues. Each of the cases, in fact, involve an action pending before a state court or territory between the same parties addressing the same issues. And then they cite a lot of case law. See Gustavia Home LLC v. VVS1 Corp. Both federal court and plaintiff and defendant were present, and issues in the state litigation may be dispositive of one of the court claims and would necessarily affect the others. Both suits have the same parties in interest and present the opportunity for ventilation of the same state law issues. Mushantov v. International Modeling and Talent Association, noting that a threshold determination is whether the state and federal proceedings are indeed parallel, i.e., whether substantially the same parties are litigating the same issues in a state forum, and concluding that this threshold is satisfied because the relevant parties are present in both actions and the gravamen of the state and federal court actions is virtually identical. Radioactive JV v. Manson, plaintiff in the federal action, was a defendant in the state action and had already filed a cross-complaint in the state court action, which is identical to the complaint in the federal action, and both actions concern the relationship of the same parties. Mashat v. Sklar, granting abstention where the main parties are involved in both the state and federal actions. Their interests in each action are identical, and the issues to be decided in both actions are substantially the same. Cisneros v. Younger, parties to the federal court action were also parties to multiple consolidated state court actions, and all actions involved liability arising from the same fire, such that the factual issues were inextricably linked. While Harco's coverage action and the California lawsuit each involve insurance coverage for the same underlying lively litigation as detailed in Harco's opposition, the above noted newly cited cases are procedurally different. Here, unlike the 7 cases above, the California lawsuit cannot qualify as a parallel action as Harco is not presently a defendant in that action, and the issues are distinct as coverage under Harco's policy at issue in this action and coverage under the separate insurance policies issued by the separate insured defendants in the California lawsuit must be evaluated separately under the separate terms and conditions of each insurer's respective insurance policy. Second, 2 of the newly cited cases in the defendant's reply are readily distinguishable because each case granted abstention a stay of a federal declaratory judgment action regarding contractual defense and indemnity obligations in deference to an underlying state court liability action where the federal and state court actions turned on the exact factual issues. See Catlin Insurance Co. v. Champ Construction Co. Further distinguishing these cases, in Catlin, this court noted that the insurer plaintiff's federal court action effectively involved the same parties as the state action because the insurer asserted only the contractual rights of its insured, i.e., Catlin brought the federal court action in the shoes of its insured, a defendant in the underlying action as its subrogee, such that that Catlin's interests were directly aligned with the party in the underlying action. Similarly, Donkor found abstention appropriate because the underlying state court action would conclusively determine the factual issues pertaining to the liability of Donkor to the underlying plaintiff and the duty to defend and indemnify raised in the federal court action was contingent on the very same factual squarely raised in which would be resolved in the underlying state court action. Here, in stark contrast with Catlin and Donkor, defendants are seeking abstention in favor of an underlying liability action to which Harco is not a party, does not involve any party with the exact same interest as Harco in this action, and will not conclusively resolve issues present in this action. Rather, the California lawsuit concerns the conduct and coverage obligations of different insurers under insurance policies with different terms and conditions. The footnote above says references to the page numbers in previously filed documents are to the page numbers listed at the top of the page added by the ECF system. Capitalized terms herein have the same meaning as in Harco's opposition brief unless otherwise stated. Finally, the remaining two newly cited cases in the defendant's reply reject abstention for many of the same reasons present here. In Dalzell Management Co. v. Bardonia Plaza LLC, the court denied abstention where, among other factors, the federal and state proceedings were not parallel because there was not an identity of parties and the issues and the reliefs were not the same. In its analysis, the court noted that if the court has any doubt regarding the parallel nature of the two actions, the outcome should be resolved in favor of exercising federal jurisdiction and that the court must analyze whether the two actions are currently parallel. Dalzell further rejected arguments suggesting that abstention was required because of the risk of piecemeal litigation by noting that the defendants before it were the ones who filed their state court action after plaintiff filed its federal court action, such that it was the defendants who created the potential for piecemeal litigation of which they complain. The court also noted that even the absence of federal issues does not strongly advise dismissal unless the state law issues are novel and particularly complex, and the ability of the state court to adequately protect plaintiff's interests is a neutral factor. Similarly, in Dittmer v. County of Suffolk, the court held that the abstention was improper under Buford and Colorado River, respectively, where the federal action does not involve a complex state administrative process or even where there is a potential for conflict with state regulatory law or policy, and despite the fact that the concurrent proceedings involve substantially the same parties litigating substantially the same issue. There's a footnote, says defendant's reply also for the first time cites Pitzer Collection v. Indian Harbor in support of its choice of law argument. Pitzer is inopposite for the reasons set forth in Harco's opposition, and because it found California's notice prejudice rule to be a fundamental public policy in the context of occurrence-based policies requiring notice as soon as practicable. In contrast, whereas here, an insurance company limits coverage of a policy based on a specific notice requirement that plain language controls. Returning to the paragraph. In sum, each of the cases cited for the first time in the defendant's reply either contradict defendant's arguments in favor of abstention or are inopposite, as they do not address a situation where, as here, the federal and state court action do not involve the same parties or issues. For these reasons and the reasons set forth in Harco's Memorandum of Law in opposition to defendant's motion for reconsideration should be denied. Respectfully submitted, Evan Shapiro.
Docket updates. Cut through the noise, cut through the lies. Come to Docket updates. We give you the filings for you to read and decide. Docket updates.